This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments. It's so nice to see you. Happy New Year, everybody. And we're starting on a really good note. Despite everything that's going on, all the policy changes we received over the holidays, and just today we received two great, wonderful approvals. We received a green card approval. This was marriage based. The interview was actually December 22nd, right before the Christmas holiday. And we just got the final word from USCIS that the green card has been approved. We are just elated. This really solidifies my purpose with all the challenges right out the bat, right out the gate. We got that green card approval within 2 weeks of the interview. Now, why is that an achievement? Because they're still slowing down. Even after the interviews, they are slowing down to really review the applications. So what we're seeing is, even in cases of overstays where someone is an immediate relative of a US citizen, that was an easy peasy case. Many times I would get approvals the day after. But what I'm seeing is that even though it's an approvable case, the USCIS is doing more looking into these types of applications. And why? Because they are really trying to sift out fraud. So what's happening is somebody may have overstayed their visa, and that's okay. But what they do want to see is the overstay as a result of fraud. So we're seeing USCIS officers now going back as far back as visa applications. So visa applications that were done at embassies abroad to see when they were coming into the country, what did they put in the application, and what were the circumstances surrounding their entry into the US. So it's just another reason to make sure that you are not taking these applications for granted just because you're the immediate relative of a US citizen, that you are very thorough. You even have to start thinking back. So in some of the cases, if there are some questions, we want to make sure we are looking at everything, that we're seeing everything that an officer would be looking at. We are going back as far back to see what's in the history of our clients that could possibly affect them, so that we won't be surprised and that we can address any questions that the immigration officers may have. So this is just an example of how the stakes are a lot higher. Now, don't take it for granted, because that is where it can really give you a nasty surprise, or you just won't be prepared to answer the questions at the interview. And a failure to answer the questions at the interview can then mean that you would be at a disadvantage. Now, even more great news, we got a T visa approval. This one, I want to talk, every time we get these approvals, I like to tell you a little about what this case looks like, so that if you are relating to a situation like this, you can also step forward and get the assistance you need to get relief here. Our client now has protection, and her family is on the way to have protection. So her family got approvals from outside of the country. They're outside of the country, in this case, Jamaica. And so they can get visas to join her here, and all of them can now be protected, right? They come in with visas, and she is now protected here. Now, in this situation, this was an H-2B visa situation. Yes, absolutely. You can be on an H-2B visa and still qualify for the T visa. As a matter of fact, this administration is looking a lot more closely at certain abuses in these types of visa programs, H-1B, H-2B visa programs. And trust me, I represent so many clients that have endured abuses that amount to being victims of trafficking, believe it or not. You can come in on a work visa and still be subject to being the victim of trafficking because an employer is very unscrupulous. They are the ones that abuse the visa program. My clients come in on the H-2B, the H-1B, they come in, they try to do everything right, and it's the employer that then turns around and refuses to pay them or doesn't pay them what they put that in the application that they would pay them. Or when they come here, they say, first of all, they attest to the government that they are going to give them 40 hours of work. They have laid out exactly the terms of the employment. And when they get here, it's completely different. They're taking them out of state and putting them in other locations to work. They're not paying them. These are examples of trafficking by fraud, right? Where our clients try to do everything right, try to comply with the visa program. As a matter of fact, they're excited that they're coming into the country with the visa, right? And all the legal protections that the visa is supposed to offer them. And then they turn around and they're mistreated or abused by the employer. And mind you, this does not have to include physical abuse. This could just be the employer lied to you on the terms of payment. They lied to you on what you would be doing to get you here. And in turn, they also lied to the government in the visa in some cases. In this case, that's what happened. They lied to the government about what they plan to do with the workers. When the workers came, they were forced to pay rent while not being given the full-time work that they were promised. So the trafficker, which in this case is the employer, who had all the permissions to carry in H-2B workers, was profiting off of the rental payments of the employees that came in on the H-2B visas, but they weren't giving these employees work. So, guys, if you are on any kind of visa programs, you don't even have to have a visa program. But I'm talking to you about this particular case that we won, so that if you can relate, you should get in touch with us and let's talk about your option. You came in on a visa. Maybe the person told you if you come in on a B1, B2 visa, they'll change your status to a bona fide working visa, or you came in on an H1B, H2B visa with all the promises of getting certain work, getting certain pay, getting certain living conditions, and then you find that these conditions are completely different. They never told you about these conditions, and had you known, you would have never signed up for this. If that's the case, give us a call, because there's protection here and there's a way for you to get relief. And if you're still in this situation, to escape this situation so that you can move forward and get what you deserve here, what you really signed up for. All right, so I just wanted to share that with you. There are some other, now, I don't know if you've seen in the news, we work with a lot of VAWA cases, T visa cases, U visa cases. We have seen the changes now that they've made regarding VAWA, the T visa, U visa. So in this case, they have basically updated the safe address provisions, which basically just gives very specific instructions on the safe address, the fact that they want to provide more access and more information to applicants about the safe address, the fact that it is there to protect the applicant who is applying for the T visa, U visa, to use a safe address in order to avoid, other people knowing what you're applying for. Because with VAWA, the T visa, U visa, these are largely based on if you've been mistreated here, if you've been victimized here. If an employer, a relative, an acquaintance, a stranger, your landlord, these types of T visa, U visa, FAWA are in place for these kinds of situations. And so in this case, you have the safe address that allows you to maintain confidentiality. Also, they have made very clear that confidentiality, so there is a rule that says they cannot use the derogatory information of a prohibited party. A prohibited party in this case would be the abuser, for example, or anybody who's on the side of the abuser or the employer. So in some cases, unfortunately, the a spouse that may be mistreating you, the relative who may be mistreating you, the employer that may be mistreating you, may be threatening to report you to ICE, or they've called ICE already to report you. And sometimes they make things up. Sometimes in many cases where you are the victim, they've made things up about you in order to get you in trouble, to get you deported, to deflect some of the wrongdoing back onto you rather on them. And in that case, we call that derogatory information. So what they're saying is that if there is a question about your admissibility, whether there's fraud involved, they can then use that information to investigate and determine an outcome. So, one, I would say this. I always say this, guys. If you have a bad feeling about your employer, they're already threatening to report you to ICE or get you deported or sabotage your interview process or write USCIS to cancel your green card process. Take action now to protect yourself, because once they submit that information, then and there's a question about whether it's fraud, most times they lie and say you tried to commit fraud. Then in that case it puts you at a very at a disadvantage, right? So it's very important that you make sure you have that gut feeling, that they're gonna follow through with that threat, especially now. Beat them to it. Get legal advice, protect yourself, understand how you can make sure you protect your rights in this immigration process. And just put yourself at an advantage. Sometimes coming forward first can give immigration the information to know that that person is telling a lie about you, right? But so that's one. That's my one recommendation in this case. It's telling me act early and act fast. You get a threat, give us a call. Let's talk about your situation. The other thing about this is that even if, so, I've had cases where they filed the green card application, right? And then the spouse that was mistreating the immigrant went to the interview and sabotaged them at the interview. If that's the case, that could be considered derogatory information if you're going for FAWA later on, because maybe they said, oh, you only married them for the green card, or they're only helping you out. We did have a case like that. It was approved because we were able to show that it was intentional sabotage. Now what they're saying is they can now consider that information, but they're not just going to give you an outright denial. They're going to give you a chance to explain why that is not true, or why you should still overcome that derogatory information to get your green card or to get your T visa. So it's not a situation where you will be denied, but you need to make sure that you understand how to overcome the negative information. So there is still protection, there's still hope. So just still get legal advice and get started right away. Act early, protect yourself early. That's going to be the key here. All right, everybody. So I'm going to answer a few questions and then I'm going to head out. It's kind of late, but I am going to be back. So, what I often say is like, follow, subscribe, hit the notification bell. That's how you're going to know when I'm on and you can hop on and ask questions. All right, so let me go ahead. Good night. How long for an I-601A visa interview at the embassy, Kingston, Jamaica? So we're seeing interviews scheduled. It's usually, I would say, prepare for a year and a half to a 2 year wait. I know it's frustrating, but that's what we're seeing right now. And with everything going on, it might be even longer. How long do you take to prepare for a T visa? So if you've been following me, you know what I'm gonna say next. The T visa is a very complex type of visa. I know we make it look easy, but we take the stress off of our clients in order while we are working on the back end. It is a very complex type of visa. And it is not, I don't run a McDonald's drive through, right? That's how people get themselves in trouble. So oftentimes, the time it takes to prepare and file a T visa is really going to be dependent on the case. So sometimes we're working on a case and there's more to it than, we have discovered additional information that we need to make sure we sift through carefully. If it's one thing you notice, USCIS is taking their time on these applications. They're really sifting through to make sure that they ask every question. And so we have to be in a situation where we also have to make sure we are turning those stones over to find all the areas where the officer may have questions, so we're prepared for it, that we address every issue. So in many cases, and if you find a good a T visa attorney, you're going to find every T visa attorney is good T visa attorney, which there are not many of us, but the ones that do work on these cases, they make sure that they go through the necessary steps. So I don't want to give a time. I want to say, though, we work as quickly as we can in each case. And when I say work as quickly as we can, if there are no issues, we work very quickly. But if there are situations, we have changing policies, we have the more scrutiny in regards to the facts and evidence and details. We need to make sure that that's solid. So that's where I don't want to give a timeline. And that's frankly why we do have good results, is because we anticipate the questions and we prepare for them. Hi, good night. Hi there. It's so nice to see you. How long to get a bona fide determination with the U visa? So we have been seeing, I would say, prepare for a year and a half to 2 years. Okay, so my wife is a practical nurse and would like to get a work permit in the US or residency. So practical nurses, you have to go through probably the EB3 process. The employer likely has to sponsor your wife to get through that process. Now, if your wife is a registered nurse, then there are more flexible employment options for registered nurses going through the process. For example, they don't necessarily need to go through the labor certification process. That makes it shorter. But keep in mind that I noticed you said work permit here. We need to understand, one, in this case, we need to have the employer, represent the employer. So the employer, needs to be 99% involved in the process. Then we need to understand your wife's status here. Is your wife, has she already overstayed her visa? Is she here on a current visa and is she trying to change status? The work permit isn't something that you can just get alone. You have to qualify for something else, like a green card, basically a green card or special types of statuses or visas. So get in touch with us. Let's talk. But just know that if your spouse only qualifies through an employer, we really would need to talk to the employer directly. I'm just going through the comments. And on Instagram and YouTube, I'm coming to you. I'm on TikTok now. I'm coming to you next. So 22 months of T visa waiting process, no work permit, no approval. Yet, is that normal from 3/18/24? Yes. Now, what happened is that the filings that were on or after August 24th, 2024 were qualified for bona fide determinations. Anybody before that, they're really focusing on trying to make the decision straight up. If they have a request for evidence, then they may issue a bona fide determination. Also, keep in mind, bona fide determinations are still discretionary. So we're not really seeing it consistent across the board the way we would see with VAWA right now. But anybody before August 24th, 2024 are likely to see a decision or a request for evidence before you see a bona fide determination letter. The good news is if you're at 22 months, it's taking about 22 months to get a decision. So a decision could be coming soon. How does it take to get approval VAWA right now? How long? So, the range of time is crazy. So I believe it's like 41 months now. We're seeing on average about 3 years, 3.5 years. Keep in mind, there are protections that are provided while the process is going forward. And thank you so much for the love on TikTok. I really appreciate it. 2,000 likes. That means that you're also helping other people to see this information that can empower them as well. Would she need a consultation with you? We're in Jamaica. Yes. So what now? Keep in mind that we have a team of attorneys here, just like me, in order to do the consultations. You can schedule your own consultation by going to the link in the profile or give us a call. We have staff 24 hours a day that are ready to get you booked and ready. We have an after hours attorney as well because we're really focused on granting access to as many people as possible. So we even have an attorney who's available after hours and guys on weekends to be able to go through your situation, see if you qualify. No, before you get to the attorney and before you pay, we offer an initial free evaluation. What that means is you'll call or you can go to the link in the profile to do an initial evaluation. And what we do is we ask questions just to make sure that you possibly qualify for something we can help you with. That way, we don't waste your time and money. I know a lot of people want to first, before you pay to talk to the attorney to get a strategy session, you want to have an idea if you have a good chance. So that is initial evaluation is there. You can complete our form online. That helps us determine whether there's possible options, and you also to determine whether this is worth your time, which it is. Once you pass our evaluation, it is, because at that point, the attorney can really delve into your facts to confirm whether you qualify for an option we can help you with. Do you do background checks on US citizens? I've never heard this before, but keep in mind if it's required, yes. So if we do need to understand, because in some cases, the background of a US citizen can really affect the case. It might offer evidence. So we have provided evidence of, delinquent behavior, of past offenses that are consistent with domestic violence or abuses or substance abuse of a US citizen. So it just depends. But if we can provide that information and it's relevant to the case, absolutely. Um, I say, no one case is the same. And that's the beauty of this law firm is we basically, I and the attorneys, as well as our paralegal, our legal assistant, we sit as a team and we go through each and every case, go through facts, and we strategize on the best way to move forward. All right. So I'm now on Instagram. So go ahead, put your questions in the comments on Instagram. Are you aware that persons are being arrested at their interviews for just overstaying their visa? So I am aware that, yes, at some interviews now we have been, um, for example, the interview where just got the green card, our client also overstayed. And what the officer said was, okay, well, in this case, we are going to take some time to review this, and we got the approval. No arrest at the interview. Now, in some cases, they are arresting people. I wouldn't say just for overstaying, and this isn't happening for everybody. While it is inconsistent, what I am seeing is there is some other variable, some other factor involved in addition to overstaying. And it really is on a case by case basis. So, this is where it's very important to ensure that you are getting the legal advice, you are having an attorney to talk to you about possible risks based on your background. Like where I would say there's a high risk, a possible high risk of an arrest at the interview is one, there's an overstay, but behind the overstay, there's no accusations of fraud, right? If they might be accused of fraudulently, uh, you know, fraudulent conduct that led to an overstay. And then the other is you may not have known that. No, you didn't know they were going to accuse you of fraud. You didn't know your risk was very high. And now at the same time, you didn't apply for a waiver, right? For the possible fraud, or you didn't have an attorney to be able to be prepared to argue why there's no fraud in this case, because it may just be an accusation. So these are things that you need to. This is just an example of some of the factors that may be playing into arrests, because under the law, simply and overstaying the visa is not going to prevent somebody from being approvable for their green card. So even if they're detained at the interview, they still can go before a judge, and the judge could grant adjustment of status because, and if there's only overstay. So that's where it's like, okay, what else is going on? And that's why you need to understand before you go into that interview. And that's where I say they're going as far back as visa interviews in your country to see what did you put in your visa interview that that before coming with that visa, and there's some kind of fraud that's connected to the overstay. Also, keep in mind another thing, another risk factor is you apply for adjustment of status and you don't qualify for adjustment of status. So you've already overstayed, but if you didn't get the proper advice, you didn't get any advice at all, you thought you could just apply for adjustment of status, and it turns out maybe your priority date isn't current because of the certain category you're in and you've overstayed, then at that point they can then I could see that as a high risk for detention at the interview. So very important you understand your risk factors before the interview. VAWA petition move to correspondence was received and USI receiving it, but it's been over 1 year. Nothing though. I do receive my prima facie renewals. So it could just be they're looking into things a little bit more. It's hard it's hard to determine what that could be. Um, but if they haven't asked for anything else, they could now just be making a decision. It might be stacked up somewhere in queue for a decision. How long does it take to get an approval fiance visa? So I would say, and the fiance visa, I would say 1.5 years to possibly even 2 years. It's very similar to the timeline of marriage based. So the marriage based process. How long did the T visa take to get approved? Exactly 22 months. So right now, the processing time is 22 months, and it really has gotten that long. So we've seen 22 months. I see you on YouTube. I see you. I'm coming soon. Would I So we do offer payment plans. If you are right now, you're in a situation where you want to continue with us or figure out our payment plans, give us a call and talk to us, and we can help you for sure. If I start T visa case with you guys and did not complete the T visa process, give us a call. Give us a call. Let's talk about your situation and continue. We're here to help. That's what this firm is here to do. So if you want to get protection, give us a call. Let's talk. No matter what stage you are in right now. It's so nice to see you all here. Good night. It's been 10 months for T visa. Do you think it's normal for nothing after biometrics? Yes, it's very normal. I would say after biometrics, you may not hear anything until the final decision at maybe a year later. Yes, it's very common. Happy New Year, Althea. Oh, thank you so much. Same to you. So nice to see you here. I have a friend of mine who married over 4 years, going on 5 years, put in their filing, never get any interviews from USCIS. That's unusual. If the case has not moved forward, it's time to figure out what went wrong there. Oops. How long does it take to get the work permit? It really depends on the case type. So it could few months, but it could also be a year, about a year. So I'd say a few months to a year. Do you know something about Haitian TPS, please? So TPS for Haitians is set to end in February of this year. It does not mean you don't qualify for anything else, but it does mean that once TPS is done, then you're no longer considered in legal status. So you have to look at what other options are available. You can always give us a call and let's talk about your situation to see if there's some other option that you can switch to continue to have status here. It's 8 years done. I still haven't had an interview, even though I have all my legal documents. Get in touch with us. That's extremely unusual. We need to understand the facts there. It sounds like there's something else going on. It could be, was it even filed? You know, I don't know what your situation is, but that is extremely unusual. Are you in Georgia? We are not physically located in Georgia, but we do represent clients in all 50 states. We are based in Delray Beach, Florida. And what that means is we can represent, even though we're based in Florida, we represent clients all over, no matter where you are. We have clients in Georgia. We have clients in Maryland, New York, Washington, California, Texas, Tennessee. So we have clients all over the country that we represent. Give us a call. If your son's girlfriend is married to another man who won't divorce her, we want to hear more about her situation. There may be options available. She may have multiple options. Sometimes that's a matter of getting a good divorce attorney too. So we can look at multiple immigration options, but keep in mind, here's another thing you should know. So if somebody won't divorce, it doesn't mean that you can't go for the divorce without involving them. So there are ways to force someone else to divorce. If they won't cooperate, a judge will surely decide that. It may, there may be additional steps to the process, but in a majority of states, you can overcome that and still go on to get a divorce. Awesome. Congratulations. My husband is now a resident. Congratulations. All right. Now I'm on YouTube. It's so nice to see you. Happy New Year. How long is it taking for a US citizen step parent to file I-130 for an underage stepchild living in South America? So if you married the parent of that stepchild before that stepchild turned 18, and you're a US citizen, it means that that stepchild is an immediate relative of a US citizen. Good news is it's a faster process. So the timeline, though, may still be about a year and a half to 2 years to get to that endpoint. Let me tell you what the timeline looks like. I-130, 9 months to 12 months for approval. Then keep in mind that's not the end of it. I-130 approval. Then what happens is they send it to the embassy in the country, so in the country in South America, and then from there, the embassy. From there, the NVC first has to get a number of documents. That often takes anywhere from 2 weeks to a month to sort out. And this is very important to avoid any mistakes there. Because if there are any mistakes there, then it means that it could be a 3-month delay. at the NVC stage. So the NVC is in charge of collecting documents. Then once all documents are collected, NVC approves it, hopefully after 3 months. What happens is it goes to the embassy and it goes into queue for the interview. We're seeing interviews being scheduled anywhere from a year to 2 years, depending on the embassy and what the processing time is looking like at that embassy. Okay, so we filed our T visa last January 7, 2025. Until now, we still didn't receive our work permit. We've got biometrics early after filing. With your client, how long you get their work permit under the T visa. So one thing I do want to say is, especially now, guys, each case is different. So you really have to look at your individual case. If you have your attorney, make sure you're talking to your attorney. Your attorney knows your case best and can explain to you why there may be differences. Keep in mind that getting the biometrics, getting a bona fide determination is great because it gives you protection, but it is not a right. It is a discretionary benefit. So we are seeing a lot of inconsistencies. Unfortunately, some of our clients get it, some of our clients are waiting until a decision. In this case, our client actually did not get the bona fide determination because, of course, she applied before that August 24th, 2024 date, where on or after that date, people were considered for the bona fide determination. So our client, even after 22 months, still got the T visa, but unfortunately was not able to get the work permit, but still ended up with an amazing result. I tell you, my client and I basically we cried tears because it's just such a huge relief after a wait. So I would say sometimes there is a lot of work. As I said before, it's a complicated type of case. There is a bit of work, and in many cases, it's still worth it because there are protections, but it sometimes there's a wait before you can get to the prize. So keep in mind that it really differs from case to case. I have a question for a friend. He has a pending asylum with EOIR and now trying to do the AOS based on EB1A I-140 approval with priority date current. Can he do the AOS? Is that possible? So there are a lot of questions here. So there's what's called Section 245K on the INA 240 Section 245K. That does provide some exceptions for individuals who were here who may have worked without authorization within 180 days, or may have not had their papers under 180 days, all right? That somehow maybe their status expired, or when their status expired, they either worked without authorization, but it has to be under 180 days, or they were out of status. So before applying for asylum, what happened there? Also, asylum is a gray area because AOS means that you do have to be in status at the time you apply for AOS. So with asylum, in many cases, it's not considered official status. So it's like a gray area. You're not out of status, you're not in status, you're not accruing unlawful presence. So we would really have to understand the history to determine whether they could fall within a Section 245K exception, or there are some circumstances here that would allow them to still move forward with adjustment of status. So it's a complicated situation. We need to talk to them for sure. The I-140 approval is great, but that's just one part of it. AOS is going to be what gets them to the green card, and we need to understand what happened there. Can I apply for my AOS with an expired I-94 that I obtained through military parole in place? Yes, yes. Now, keep in mind, I don't know your circumstances. I'm not your attorney. And let me just say that for everybody here, the information I'm giving you, the questions that I'm answering here is not personalized legal advice. It's general information. So please make sure that you take that with a grain of salt, and this is where scheduling a consultation with us in order to let us give you personalized legal advice and figure out your circumstances is going to be key here. Here's a good question, and thanks for raising this. If you got T status and you are from banned countries, is your AOS going to be on hold as well? Unfortunately, yes. Now, what I would say here is, guys, because they have paused it does not mean you should not move forward with applying. That can actually compromise you. It's still important to get in touch and get personalized legal advice. But I'll give you an example. If you qualify for VAWA and you're from a banned country, but you say you're divorced, you've been divorced within 2 years of the VAWA, the 2 years from the spouse that's mistreating you. The deadline is approaching, right? Because after 2 years, you can no longer apply for VAWA to get a green card without that spouse, that divorced spouse. Just because it is paused does not mean that you're going to forfeit that right to apply for VAWA. Because once you forfeit that right, because you see that the cases are paused, it means you'll never get to. What the pause means is that you apply, there's going to be a pause while they're figuring out the extra vetting that they have to do. But once they get started again, you would have applied within the deadline. So you would have been able to hold on to your legal right to apply for this benefit, right? Asylum is another situation. If you have 1 year from the date of your entry to apply for this, but say you see every case from a banned country is now paused, you should not be sitting down and thinking, I'm not going to apply because it's all cases are paused. So that means that you would have missed a deadline, that after the deadline you no longer qualify. So you still have to explore whether it is a good option to move forward with whatever you qualify for, still move forward with it. So I have filed a T visa in March 2025, received message that they are using existing biometrics, but still don't receive BFD EAD. I have very strong case. What is the process time for T visa bona fide EAD? So we're seeing 8 months to 10 months for bona fide determination EADs. And right now, it really is not very consistent. We've been getting some in, but it's inconsistent. Some of our clients are waiting, and some clients are getting it. As I said before, for example, the client that just got approved never got the BFD EAD, but was approved and now is in a much better position, can apply for the green card, can have her family here in the U.S. On a visa. All right, that's gonna be it from me, guys. I'm so thankful that you all came. It's been good to see you all, especially on going into the new year. I'm looking forward to a great year of changing lives and maintaining faith, maintaining hope, and taking action accordingly. Doesn't mean it's going to be easy, but that's why I'm here. Doesn't mean that any of it is going to be easy, but with hard work, with hope, with faith, and action, we are going to forge forward. And the approvals, the most recent approvals that we've gotten so far, have solidified my resolve to fight for our clients, fight for their ability to be here, to get protections and benefits that they deserve. So give us a call. We have all the people in place to help you, to get you started. Now, before I leave, I also want to say this. I come on as soon as I can. As you can see, immigration is very busy right now. So we are really, I'm really in the trenches right now. So what you need to do is, if you want to see when I come on live and join me to ask questions, make sure you like, subscribe, hit the notification bell, share the post, share videos, so that when I come on, you can come on as well and ask questions, or just come on for updates, because that's exactly what I do as well. I give updates on, and I even do it on regular posts as well. All right. Have a good night, everybody, and just hang tight, work hard, make sure you take action to protect yourself, and let's keep forging forward with hope, faith, and resolve. All right. Bye bye.